Hello and welcome. It is lovely to be back live with you this week, this lovely Wednesday afternoon. I'm here in Sydney. I'm looking out my office window. It's looking a little bit grey, a little bit drizzly, but I am very happy to be here with you to dive into another hot strata topic. And I hope you can all hear me. I have had an adjustment to my microphone here today. So we've done a few tests and I'm hoping that it is all working. But if anyone is having trouble hearing me, please do shoot me a comment. Now, I have spent the last couple of days putting together an application to the New South Wales Civil and Administrative Tribunal for the appointment of a strata managing agent to a strata scheme, but a little bit different to your normal appointment. This strata managing agent is going to have all the powers of the owners corporation and the strata committee. So those of you who might know a little bit about this stuff may refer to this kind of appointment as a compulsory management or as an administrator managing a strata scheme. And I thought I'd jump on because my brain is full of this stuff today and was yesterday, and fill you in a little bit about that process. So settle in. Welcome, Ash. Lovely to see you here. Hi. Great to know that you can both hear and see me. Fine. Good to know. If you, as I always say, if you have friends, family, colleagues who you think might benefit from some more information about strata, about apartment living, about the legal complexities around apartment living, knowledge is power, I say, and the best way to improve your experience of living in or investing in a strata apartment is to improve your knowledge. So do feel free to share this video with friends, family members. If you manage a page, big thanks, a bit of a shout out to Nikki Djokovic managing Look Up Strata. I know that she does share these videos to her page, and I'm very grateful for that. And I hope that those who are following her page get great value from it as well. As always, I am happy to answer your questions off the cuff if you want to post them into the comments section. I love a good Q&A. But today, let's get stuck into our topic, the appointment of a compulsory manager or an administrator to manage a strata scheme. Now, the relevant section of the legislation in New South Wales, which you might want to have a little look at, is section 237 of our Strata Schemes Management Act. And you do need to apply to the tribunal for this kind of appointment. In what circumstances do you do it? Well, you do it when your owner's corporation is just not functioning, or as the section says, not functioning satisfactorily. So we are dysfunctional. We are not compliant with the legislation. Owners are perhaps not paying their levies, or we can't get levies struck because we've got some kind of a stalemate or a voting block. We're not repairing and maintaining the common property. Things are in a bit of a mess. And as a lot owner, that can be very, very frustrating. And you feel like communicating with the committee is not getting you anywhere. Communicating with your strata manager, if you have one, an existing one, is not getting anywhere, and things just aren't getting done. So you might have a look at making this kind of application. It is quite a serious application. The tribunal does not make these orders lightly, of course, because to take power away from you as a strata committee, as an owner in your building, is a very serious thing to do. So these applications need to be put together after much thought and consideration. So the tribunal is going to be looking at how the management structure of the owners corporation is going. As I said, we need to show that it's not functioning or not functioning properly. The tribunal is going to look at whether the owners corporation is failing to comply with a requirement that's imposed on it by a section of the Act. So, for example, a big one is the requirement to repair and maintain common property. Are they doing that? If there has been an order made against the owners corporation previously by the tribunal and they haven't complied with that order, then that's another ground for appointing a compulsory manager. And really interestingly, another ground that is in section 237 for the appointment of a compulsory manager is if the owners corporation has failed to pay a judgment debt. So judgment creditors, those who have sued the owners corporation and are owed money by the owners corporation, and the court has said that there is a debt, they can apply to have a compulsory strata manager appointed so that they can get paid. And I have successfully seen lawyers do this in the past to get their bills paid. So a powerful provision there, if you like, for creditors, whether they are professionals or trades who are owed money by an owners corporation, and they just can't get their hands on that because the owners refuse to pay or won't raise the money, or levies just aren't getting paid. So what you need in this application is to show all of those things, that the owners corporation is not functioning, not complying with its duty. You need to file evidence of that. So I generally find when clients come to me wanting this kind of appointment, they're really eager and say, Amanda, you know, we're just at our wits' end. We want to file this application. Let's get a compulsory manager in. And I say, well, hang on a sec. We have to set the path first. We have to establish and show the tribunal that this dysfunction is happening. So how do you do that? Well, you ask the owners corporation to do things, and then when they fail to do things, then they've shown that they're not functioning properly, they're not meeting their duties, and you then have a paper trail. You've collected your evidence, you've written letters that haven't been responded to, you've asked the owners corporation through the Strata committee to take certain steps, they haven't done it, and you have that trail that you can then present to the tribunal, and that can take a while. Buildings that I've been involved with, owners I've been helping, we've often gone through a period of up to 12 months where we have been trying to straighten things out, and sometimes the intervention of a lawyer can do that, and we haven't been successful, so we've had to take that next step of applying to the tribunal for the appointment of a managing agent, so of a compulsory managing agent with all those powers. You must have an agent in mind. So you must choose an agent that you would be happy to have servicing the owners corporation in that way. Make a very, very careful choice, because this person has a lot of power to make decisions that are going to affect you and affect your funds and the way that you live in your home or manage your investment. You need to get an agency agreement from that person, and you need to get a letter of consent. So those things need to be filed with your application. And obviously the person has to be a strata manager who holds a strata managing agent's license, and as I said, have given their consent. Now, the appointment can be made for a period of up to 2 years. I generally find that 12 months is about the norm in really serious cases where perhaps there's a lot of work to be done to the building. We've got a major works project. The appointment goes for longer. It can be extended by further order, but certainly not past that 2-year period. And this person has some pretty serious powers. We do have case law here in New South Wales. Our Court of Appeal, almost 10 years ago now, I think it was 2009, decided a case called Andrews, and that essentially made clear that strata managers have very broad powers under these appointments. They don't have to hold meetings. They don't have to ask you as an owner what it is that you want to do with the building. They can just make decisions that they think are in the best interests of the owners and the owners corporation as a whole. So people have had bad experiences with these kinds of appointments, because the agent who's been appointed, some of the owners have thought that the agent doesn't have the best interests of the owners in mind, and things have been done, bylaws have been made or changed, levies have been raised, and owners are not happy. So it's important to be, if you are proposing an agent, as I said, to be very careful about who that is and make sure it's someone that you have a good rapport with and is a highly professional person. We have spoken about this on the podcast. If you head over and check out episode 84, I think that was an in-conversation episode between me and Rena, and we actually got stuck into some of those problems around appointing compulsory managing agents and having them in place with all of those powers. So episode 84 over at yourstrataproperty.com.au/podcast. You can check that out. And that is my whirlwind summary of appointing a managing agent with all the powers of the Owners Corporation and the Strata Committee. I I've separated out those two concepts because you can actually seek orders that the agent only have the powers of the Strata Committee, or that the agent have all the powers of the Owners Corporation and of the Strata Committee. So that's something to be mindful of when you're framing your application. Exactly what is it that you want this agent to be able to do? All right, I think that is it from me this week in video form. Enjoy the rest of your week in Strata, as I like to say, and I hope to be back next week around same time, same place, getting closer to Christmas. I hope you're all enjoying your end of year wrap-ups and Christmas parties. I'm certainly enjoying mine, trying to get everything squeezed in between, and I shall catch you guys next time. Thanks.